That parliaments have more than once intended and endeavoured to pass acts which should tie the hands of their successors is certain, but the endeavour has always ended in failure. Of statutes intended to arrest the possible course of future legislation, the most noteworthy are the acts which embody the treaties of union with Scotland and Ireland. The legislators who passed these acts assuredly intended to give to certain portions of them more than the ordinary effect of statutes. Yet the history of legislation in respect of these very acts affords the strongest proof of the futility inherent in every attempt of one sovereign legislature to restrain the action of another equally sovereign body. Thus the Act of Union with Scotland enacts in effect that every professor of a Scotch university shall acknowledge and profess and subscribe the confession of faith as his profession of faith, and in substance enacts that this provision shall be a fundamental and essential condition of the Treaty of Union in all time coming. But this very provision has been in its main part repealed by the Universities (Scotland Act 1853, which relieves most professors in the Scotch universities from the necessity of subscribing the confession of faith. Nor is this by any means the only inroad made upon the terms of the Act of Union. From one point of view at any rate, the Act 10 Ann c. 12, restoring the exercise of lay patronage, was a direct infringement upon the Treaty of Union. The intended unchangeableness and the real liability of these acts or treaties to be changed by Parliament comes out even more strikingly in the history of the Act of Union with Ireland. The 5th article of that Act runs as follows, quote, "That it be the 5th article of Union, that the churches of England and Ireland, as now by law established, be united into one Protestant Episcopal Church, to be called the United Church of England and Ireland, and that the doctrine, worship, discipline, and government of the said United Church shall be and shall remain in full force for ever, as the same are now by law established for the Church of England, and that the continuance and preservation of the said United Church, as the established Church of England and Ireland, shall be deemed and be taken to be an essential and fundamental part of the Union." End quote. That the statesmen who drew and passed this article meant to bind the action of future parliaments is apparent from its language. That the attempt has failed of success is apparent to everyone who knows the contents of the Irish Church Act 1869. One act, indeed, of the British Parliament might, looked at in the light of history, claim a peculiar sanctity. It is certainly an enactment of which the terms, we may safely predict, will never be repealed and the spirit will never be violated. This act is the Taxation of Colonies Act 1778. It provides that Parliament, quote, "will not impose any duty, tax, or assessment whatever payable in any of His Majesty's colonies, provinces, and plantations in North America or the West Indies, except only such duties as it may be expedient to impose for the regulation of commerce. The net produce of such duties to be always paid and applied to and for the use of the colony, province, or plantation in which the same shall be respectively levied, in such manner as other duties collected by the authority of the respective general courts or general assemblies of such colonies, provinces, or plantations are ordinarily paid and applied." End quote. This language becomes the more impressive when contrasted with the American Colonies Act 1776, which, being passed in that year to repeal the acts imposing the stamp duties, carefully avoids any surrender of Parliament's rights to tax the colonies. There is no need to dwell on the course of events of which these two acts are a statutory record. The point calling for attention is that though policy and prudence condemn the repeal of the Taxation of Colonies Act 1778, or the enactment of any law inconsistent with its spirit, there is under our Constitution no legal difficulty in the way of repealing or overriding this act. If Parliament were tomorrow to impose a tax, say on New Zealand or on the Canadian Dominion, the statute imposing it would be a legally valid enactment. As stated in short by a very judicious writer, quote, "It is certain that a Parliament cannot so bind its successors by the terms of any statute as to limit the discretion of a future Parliament, and thereby disable the legislature from entire freedom of action at any future time, when it might be needful to invoke the interposition of Parliament to legislate for the public welfare." End quote. Parliamentary sovereignty is therefore an undoubted legal fact. It is complete both on its positive and on its negative side. Parliament can legally legislate on any topic whatever which, in the judgment of Parliament, is a fit subject for legislation. There is no power which, under the English Constitution, can come into rivalry with the legislative sovereignty of Parliament. No one of the limitations alleged to be imposed by law on the absolute authority of Parliament has any real existence, or receives any countenance, either from the statute book or from the practice of the courts. This doctrine of the legislative supremacy of Parliament is the very keystone of the law of the Constitution. But it is, we must admit, a dogma which does not always find ready acceptance, and it is well worth while to note and examine the difficulties which impede the admission of its truth. I'm going to read a long footnote from pages 24 and 25 now. The logical reason why Parliament has failed in its endeavours to enact unchangeable enactments is that a sovereign power cannot, while retaining its sovereign character, restrict its own powers by any particular enactment. An act, whatever its terms, passed by Parliament might be repealed in a subsequent or indeed in the same session, and there would be nothing to make the authority of the repealing Parliament less than the authority of the Parliament by which the statute, intended to be immutable, was enacted. Limited sovereignty, in short, is, in the case of a parliamentary as of every other sovereign, a contradiction in terms. Its frequent and convenient use arises from its in reality signifying and being by any one who uses words with any accuracy understood to signify that some person, e.g. a king, who was at one time a real sovereign or despot, and who is in name treated as an actual sovereign, has become only a part of the power which is legally supreme or sovereign in a particular state. This, it may be added, is the true position of the king in most constitutional monarchies. Let the reader, however, note that the impossibility of placing a limit of the exercise of sovereignty does not in any way prohibit either logically or in matter of fact the abdication of sovereignty. This is worth observation because a strange dogma is sometimes put forward that a sovereign power, such as the Parliament of the United Kingdom, can never by its own act divest itself of sovereignty. This position is, however, clearly untenable. An autocrat, such as the Russian Tsar, can undoubtedly abdicate, but sovereignty or the possession of supreme power in a state, whether it be in the hands of a Tsar or of a parliament, is always one and the same quality. If the Tsar can abdicate, so can a parliament. To argue or imply that because sovereignty is not limitable, which is true, it cannot be surrendered, which is palpably untrue, involves the confusion of two distinct ideas. It is like arguing that because no man can, while he lives, give up, do what he will, his freedom of volition, so no man can commit suicide. A sovereign power can divest itself of authority in two ways, and, it is submitted, in two ways only. It may simply put an end to its own existence. Parliament could extinguish itself by legally dissolving itself and leaving no means whereby a subsequent Parliament could be legally summoned. See Bryce, American Commonwealth, 1, 3rd edition, page 242, note 1. A step nearly approaching to this was taken by the bare-bones Parliament when, in 1653, it resigned its power into the hands of Cromwell. A sovereign again may transfer sovereign authority to another person or body of persons. The Parliament of England went very near doing this when, in 1539, the Crown was empowered to legislate by proclamation, and, though the fact is often overlooked, the Parliaments both of England and of Scotland did, at the time of the Union, each transfer sovereign power to a new sovereign body, namely the Parliament of Great Britain. This Parliament, however, just because it acquired the full authority of the two legislatures by which it was constituted, became in its turn a legally supreme or sovereign legislature, authorised therefore, though contrary perhaps to the intention of its creators, to modify or abrogate the Act of Union by which it was constituted. If indeed the Act of Union had left alive the Parliaments of England and of Scotland, though for one purpose only, namely to modify when necessary the Act of Union, and had conferred upon the Parliament of Great Britain authority to pass any law whatever which did not infringe upon or repeal the Act of Union, then the Act of Union would have been a fundamental law unchangeable legally by the British Parliament. But in this case the Parliament of Great Britain would have been, not a sovereign, but a subordinate legislature, and the ultimate sovereign body, in the technical sense of that term, would have been the two Parliaments of England and of Scotland respectively. The statesmen of these two countries saw fit to constitute a new sovereign parliament, and every attempt to tie the hands of such a body necessarily breaks down on the logical and practical impossibility of combining absolute legislative authority with restrictions on that authority which, if valid, would make it cease to be absolute. The historical reason why Parliament has never succeeded in passing immutable laws, or in other words has always retained its character of a supreme legislature, lies deep in the history of the English people and in the peculiar development of the English constitution. England has, at any rate since the Norman Conquest, been always governed by an absolute legislator. This lawgiver was originally the Crown, and the peculiarity of the process by which the English constitution has been developed lies in the fact that the legislative authority of the Crown has never been curtailed, but has been transferred from the Crown acting alone, or rather in council, to the Crown acting first together with and then in subordination to the Houses of Parliament. Hence Parliament, or in technical terms the King in Parliament, has become, it would perhaps be better to say has always remained, a supreme legislature. It is well worth notice that on the one occasion when English reformers broke from the regular course of English historical development, they framed a written constitution, anticipating in many respects the constitutionalism of the United States, and placed the constitution beyond the control of the ordinary legislature. It is quite clear that, under the instrument of government of 1653, Cromwell intended certain fundamentals to be beyond the reach of Parliament. It may be worth observing that the Constitution of 1653 placed the executive beyond the control of the legislature. The Protector, under it, occupied a position which may well be compared either with that of the American President or of the German Emperor. See Harrison, Cromwell, pages 194 to 203, for a view of sovereignty which, though differing to a certain extent from the view put forward in this work, is full of interest and instruction. My readers are referred to Professor Sidgwick's Elements of Politics, Chapter 31, Sovereignty and Order. End of footnote. Difficulties as to the doctrine of parliamentary sovereignty. The reasons why many persons find it hard to accept the doctrine of parliamentary sovereignty are twofold. The dogma sounds like a mere application to the British Constitution of Austin's theory of sovereignty, and yet intelligent students of Austin must have noticed that Austin's own conclusion as to the persons invested with sovereign power under the British Constitution does not agree with the view put forward, on the authority of English lawyers, in these lectures. For while lawyers maintain that sovereignty resides in Parliament, i.e. in the body constituted by the King, the House of Lords and the House of Commons, Austin holds that the sovereign power is vested in the King, the House of Lords and the Commons or the electors. Everyone, again, knows as a matter of common sense that, whatever lawyers may say, the sovereign power of Parliament is not unlimited, and that Kings, Lords and Commons united do not possess anything like that restricted omnipotence, if the term may be excused, which is the utmost authority ascribable to any human institution. There are many enactments, and these laws not in themselves obviously unwise or tyrannical, which Parliament never would and, to speak plainly, never could pass. If the doctrine of parliamentary sovereignty involves the attribution of unrestricted power to Parliament, the dogma is no better than a legal fiction, and certainly is not worth the stress here laid upon it. Both these difficulties are real and reasonable difficulties. They are, it will be found, to a certain extent connected together, and well repay careful consideration. As to Austin's theory of sovereignty in relation to the British Constitution, sovereignty, like many of Austin's conceptions, is a generalisation drawn in the main from English law, just as the ideas of the economists of Austin's generation are, to a great extent, generalisations suggested by the circumstances of English commerce. In England we are accustomed to the existence of a supreme legislative body, i.e. a body which can make or unmake every law, and which therefore cannot be bound by any law. This is, from a legal point of view, the true conception of a sovereign, and the ease with which the theory of absolute sovereignty has been accepted by English jurists is due to the peculiar history of English constitutional law. So far, therefore, from its being true that the sovereignty of Parliament is a deduction from abstract theories of jurisprudence, a critic would come nearer the truth who asserted that Austin's theory of sovereignty is suggested by the position of the English Parliament, just as Austin's analysis of the term law is at bottom an analysis of a typical law, namely, an English criminal statute. It should, however, be carefully noted that the term sovereignty, as long as it is accurately employed in the sense in which Austin sometimes uses it, is a merely legal conception and means simply the power of lawmaking unrestricted by any legal limit. If the term sovereignty be thus used, the sovereign power under the English Constitution is clearly Parliament, but the word sovereignty is sometimes employed in a political rather than in a strictly legal sense. That body is politically sovereign or supreme in a state, the will of which is ultimately obeyed by the citizens of the state. In this sense of the word, the electors of Great Britain may be said to be, together with the Crown and the Lords, or perhaps in strict accuracy, independently of the King and the Peers, the body in which sovereign power is vested. For, as things now stand, the will of the electorate, and certainly of the electorate in combination with the Lords and the Crown, is sure ultimately to prevail on all subjects to be determined by the British government. The matter indeed may be carried a little further, and we may assert that the arrangements of the Constitution are now such as to ensure that the will of the electors shall by regular and constitutional means always in the end assert itself as the predominant influence in the country. But this is a political, not a legal fact. The electors can in the long run always enforce their will, but the courts will take no notice of the will of the electors. The judges know nothing about any will of the people except in so far as that will is expressed by an Act of Parliament, and would never suffer the validity of a statute to be questioned on the grounds of its having been passed or being kept alive in opposition to the wishes of the electors. The political sense of the word sovereignty is, it is true, fully as important as the legal sense, or more so. But the two significations, though intimately connected together, are essentially different, and in some part of his work Austin has apparently confused the one sense with the other. He writes, quote, "Adopting the language of some of the writers who have treated of the British Constitution, I commonly suppose that the present Parliament, or the Parliament for the time being, is possessed of the sovereignty, or I commonly suppose that the King and the Lords, with the members of the Commons House, form a tripartite body which is sovereign or supreme. But, speaking accurately, the members of the Commons House are merely trustees for the body by which they are elected and appointed, and consequently the sovereignty always resides in the King and the Peers, with the electoral body of the Commons. That a trust is imposed by the party delegating, and that the party representing engages to discharge the trust, seems to be imported by the correlative expressions delegation and representation. It were absurd to suppose that the delegating empowers the representative party to defeat or abandon any of the purposes for which the latter is appointed. To suppose, for example, that the Commons empower their representatives in Parliament to relinquish their share in the sovereignty to the King and the Lords." End quote.